Thank you, Mr. Speaker. For the purposes of debate only, I will yield the customary 30 minutes to the gentleman from Pennsylvania, pending which I yield myself such time as I may consume. During consideration of this resolution, all time yielded is for the purposes of debate only. I ask unanimous consent that all members be given 5 legislative days within which to revise and extend their remarks.
Without objection.
Mr. Speaker, on Monday, the Rules Committee met and reported a rule, House Resolution 1023. The rule provides for consideration of the resolution accompanying House Report 117-284 under a closed rule if the report is called up by direction of the Select Committee to investigate the January 6th attack on the United States Capitol. The rule provides 1 hour of debate equally divided among and controlled by Chairman Thompson, Vice Chair Cheney, and an opponent. Mr. Speaker, if 90% of success in life is just showing up, then 90% of acting in contempt of Congress is not showing up by failing to respond to multiple subpoenas you have been lawfully served. The rest of contempt is not turning over documents you have been ordered to produce and acting with open disregard and scorn for the rule of law, Congress, and representatives of the American people. Neither Dan Scavino nor Peter Navarro has shown up in response to repeated congressional subpoenas. They have blown us off completely. Neither Mr. Scavino nor Mr. Navarro has produced a single document or offered 1 minute of testimony in response to the subpoenas sent by the House of Representatives. While more than 800 Americans have come forward voluntarily or properly responded to congressional subpoenas, which are orders under penalty of law saying you must show up to testify under oath and invoke any asserted privileges in person, Scavino and Navarro have followed Steve Bannon in acting as if they are way too busy and way too important to bother with the mere United States House of Representatives. They think that having worked for a former president of the United States excuses them from complying with lawful orders. This is clearly false. This is clearly wrong, and we must make an emphatic statement about it today. Mr. Speaker, I ask America to consider this. If your son or daughter were subpoenaed to come testify before the Congress of the United States, would you advise them to sit home on the couch and blow it off? I know I wouldn't. Every year, thousands of Americans are held in criminal contempt for ignoring their legal obligations to comply with a lawful subpoena issued by courts or legislative bodies. Here in the District of Columbia, you can be sent to jail for 6 months and fined $1,000 for acting in contempt of a subpoena and not showing up. We have checked on multiple days and found on any given day 7, 8, 10, or a dozen people are being found guilty of contempt in the courts of the District of Columbia. That's the exact same criminal offense that Mr. Scavino and Mr. Navarro committed, and that is the exact same penalty they are facing for their misconduct. Each of these witnesses was given ample and repeat opportunities to comply, opportunities that continue to this day, and yet they openly and brazenly flout the authority of the Congress and mock their own personal duty to comply with the rule of law. Legal contempt exists for those who act with open disregard or disobedience of the law, especially when acting with scorn for the authority of government. It exists precisely for cases like this. Here's what's happened with Mr. Scavino. In September of last year, the committee issued its first of 3 subpoenas. We asked him to come testify before us on October 15th, 2021 of last year. When he could not be found to actually accept service of the first subpoena, we issued a second subpoena, asking him to appear before the committee on October 28, 2021. He told the committee that wasn't enough time for him. He needed 1 extra week. So we generously gave him a week, and we set a third deposition date of November 4th, 2021. But he didn't come on November 4th either. Instead, he requested another extension. And so, bending over backwards to accommodate this witness, we set a fourth deposition date of November 12, 2021. And still that wasn't enough time for him. We acted in good faith again, and assuming he was acting in good faith, we set a fifth deposition date of November 19. And when that day arrived, did he finally show up to do his civic duty? No, he did not. Instead, he waited until the eve of the deposition and now, for the first time, challenged the service of the subpoena. Out of an abundance of deference and caution, and to make every effort to demonstrate the respect for the rule of law that Scavino was not showing, we issued yet a third subpoena, inviting him to come testify before us once again on December 1, 2021. And finally, with Scavino completely out of excuses and the committee out of patience, his final deposition date of December 1 arrived, and he simply did not show up. 6 times this committee invited Scavino to testify, and 6 times he stood us up. He stood the American people up. He refused to testify before Congress about what he knows about the most dangerous and sweeping assault on the United States Congress since the War of 1812, and that was by a foreign power. But even after he failed to show up in December, the committee held an open door for Mr. Scavino to come in and testify. But in the more than 6 months since the committee's first subpoena was sent to him, he has never once come in to speak with us. He has not given us a single document, Mr. Speaker. And it's the same basic story with Mr. Navarro. On February 9th, we issued him a subpoena to produce documents on February 23rd and to testify on March 2nd. It has been repeated evasions and contortions by the witness since then. Generous accommodations offered by the committee, and all of it leading to nothing but his open contempt and mockery for this process and for the rule of law. He never showed up, and he never produced a single document when more than 800 Americans have voluntarily testified and complied with the subpoenas rendered by our committee. The witnesses have nothing but excuses for their noncompliance, excuses you would not accept from a teenage child. Navarro says he wants us to send him written interrogatories, and he'll answer his questions in writing. Well, wouldn't that be nice? Any witness to a car accident, a murder, an assault, or an insurrection in the land would love not to have to answer actual questions under sworn oath. But that's not how our system works. The word subpoena means under the penalty of law. Sub means under, pena standing for penalty of law. Under the penalty of law, you show up and you answer questions in the United States of America. And if you think you have a legal privilege excusing you from answering questions, you assert your privileges under oath at the time of questioning that you show up to specific questions, whether it's the attorney-client privilege, the Fifth Amendment privilege against self-incrimination, which a number of witnesses have asserted before our committee, as it is their legal right to do, the priest-penitent privilege, or the executive privilege. The court has been clear. The Supreme Court has been clear. If you think you've got one of these privileges, you show up and you assert it to the specific questions being asked to you. But the privilege against self-incrimination, the executive privilege, the marital privilege, none of these is a magic wand that you can wave from your sofa and not show up under a subpoena to a lawful proceeding. But Navarro continues to mutter the words executive privilege as if it is some kind of magic wand that would keep him from ever having to testify about anything, like Harry Potter's invisibility cloak. He even says repeatedly, the executive privilege is not mine to waive, which is high comedy, Mr. Speaker, because it is not his to waive, which means by definition it is not his to invoke in the first place. And we know it is not his to invoke. The Supreme Court's been clear about this too. The executive privilege belongs to the President of the United States of America, the actual President. And President Biden has specifically decided not to invoke executive privilege in Navarro's case or in Scavino's case. Yet Navarro says that the executive privilege here belongs to ex-President Donald Trump, which is not only extremely dubious, but totally irrelevant. It is dubious because the Supreme Court just rejected a claim by Donald Trump himself in Trump v. Thompson that his materials were protected from disclosure to the January 6th Select Committee and Congress by executive privilege. Even if Trump were still the president, the court essentially said there is an overwhelming public interest in these materials that dwarfs whatever dubious interest in executive secrecy may linger. So the claim would fail even if President Joe Biden were himself here to assert it on behalf of Navarro and Scavino. But Navarro's attempt to stand above the law by mentioning Donald Trump's name is also completely irrelevant. Why? Everyone please take note of this, because Donald Trump has never even asserted the executive privilege to cover Peter Navarro, not once. We've received no communication from Donald Trump, either directly or indirectly, from Navarro, showing that Trump is trying to exercise an executive privilege claim, which is doomed to failure anyway under the logic of the decision just rendered by the Supreme Court. So what do we have, Mr. Speaker? Two guys in the District of Columbia blowing off a congressional investigation and subpoenas into a deadly insurrection which caused multiple deaths, inflicted brutal, savage injuries on 150 of our officers who ended up with broken jaws, necks, vertebrae, noses, traumatic brain injuries, post-traumatic stress syndrome, and interrupted Congress from executing its constitutional duties by counting electoral college votes for the very first time in American history. Oh yes, and it nearly succeeded in overthrowing the 2020 presidential election and toppling the peaceful transfer of power, perhaps for all time, as United States District Court Judge Carter wrote in a blistering opinion last week, rejecting this exact same and equally ridiculous claims of John Eastman, who helped cook up the absurd legal camouflage for this attempted coup in the first place against the American constitutional system of government. The gentlelady, I think, said something about the Russian hoax or Russian collusion. I accept the heckling, Mr. Speaker, that's all right. Because if she wants to continue to stand with Vladimir Putin and his brutal, bloody invasion against the people of Ukraine, she is free to do so. And we understand there is a strong Trump-Putin axis in the gentlelady's party. If she wants to continue to stand with Vladimir Putin and Donald Trump, that is her prerogative. But please do it on your own time, forthwith. Mr. Speaker, I will reserve the balance of my time.